thank you all for coming. We'll probably gather a few more as we go along. The topic today, as you know, is on the plethora of privacy regulations which are starting to come out in various different parts of the world. And to address them, as we've just been told, we have an excellent panel of experts on the privacy regulations, either in terms of struggling with how they become incorporated into their own corporations. Some are representing law firms, some are consultants, and we also have an author who's written a book on the Indian privacy regulations. So we'll try and cover all the topics. We'll try and get some sense of what your questions are as well, and we'll keep it as a fairly informal panel. But to start off, it's always good when a regulation comes out to say, why? What is the purpose of this regulation? Or what is the problem this regulation is trying to solve? Or is there a problem this regulation is trying to solve? And there's two fairly obvious ones. One is the enormous amount of cyber theft, which, as I think all of us have an interest in IP particularly, should be concerning us. According to a White House study, so we know it has to be true, we have over $1 trillion worth of IP stolen just from the US alone every year. And that's probably an underestimate in my opinion. Then on the other hand, we also have identities being stolen. The recent Move-It breach. It's difficult to get the numbers because everyone's kind of hiding them, but it looks like about 1 billion identities were compromised. That's a significant portion of the world population. And which is the most serious? I don't know. At least with your identity, you can kind of get it back. You can change all your passwords, and it's a big hassle. But if your ideas are stolen, that's something you never really get back. So we have a whole channel of experts to address the various questions, because all these privacy regulations, they tend to overlap, sometimes they contradict, and it's totally bewildering. So the organizers put together an excellent panel of experts in this field, and they will be able to answer all your questions. But I'll mention two more things before I pass along to the panel. I think a broader problem that we're facing is if you take the two largest industries and the fastest growing industries, I should say, in the world today. One is the AI industry, which used to be called analytics and was called big data, and now it's called AI. It's basically evolved, which is growing with, the most conservative estimate is about a 37% CAGR. I've seen estimates that go up as high as 70%. And then the cybersecurity is no slouch either. That's growing probably close to 10% every year. So you've got these two very fast growing industries, but they're kind of on a collision course, because the AI industry is trying to gather as much data as it can and get access to as much data as it can. And the cybersecurity industry is trying to make sure you get as little access to the data as possible. So they're on a kind of collision course. And that actually brings up another interesting point, because there is a potential solution. There's a new technology that's really only become available in the last year that I think is very pertinent to this whole issue of privacy. And it came out of the City University of New York. It's existed for about 20 years, but it's never been viable until this last year. And there's an algorithm coming out of the City University of New York which solves it. The technology I'm talking about, let's see if the next slide addresses it. Yes, it does. It's a form of encryption. And normally with encryption, you encrypt a file and you can't do anything with that file until you decrypt it. It's a problem for cybersecurity, because anytime you want to operate on that file, you decrypt it and an attacker can grab it quickly. And it's a problem for the AI industry, because you can't get access to a lot of the encrypted data normally. You can't train your AI models with encrypted data. With fully homomorphic encryption, it's different. With fully homomorphic encryption, you can encrypt the file, and while it's encrypted, you can search for keywords, or you can run statistical operations on the file. You can add, multiply, run more complex functions, and even train AI models with encrypted data. So I think, no one's really talking about it now, so you're perhaps hearing about it for the first time. But I think it's going to be very important to this discussion, so I wanted to bring it up as well. And I'll just give you two quick examples of where it impacts, and one in a moment where it impacts what we're interested in, which is IP and how you protect it. And separately, specifically trade secrets and pre-patent IP. Before, when we talked about access, which is what the privacy regulations are all talking about, it was binary. You had access or you didn't have access. Now we've added two more layers. You can have access automatically, or you can have access if you demonstrate your need to know, which is a fairly common intelligence community protocol. They don't want to give even though the employees have been cleared, have got security clearances. Can everyone hear me, by the way?
Yes.
Everyone's got security clearances, but they don't want to let everyone loose on everything. But if they can demonstrate they need to know something, then they can have access. So that's one level of access. They can search for the keywords with FHE encrypted files, and if they get a hit, then they can automatically be granted access to the decrypted information. Or you can have a more cautious level of access where if you get a hit, you're searching again the FHE file, you get a hit, you can request access. And I'll just show you how that works. And I have to disclose some level of self-interest here because we're interested in this area and we're trying to make it work in conjunction with the City University of New York. But for those of us worried about IP, one of the biggest problems is how can you get people to collaborate when it's all secret? Or how can you market your IP when it's secret? And it's not just trade secrets, it applies to pre-patents before the patent gets published. So how do you do this? Well, one approach that ideation has taken is inventors can send in their inventions encrypted when it leaves the browser. All these encrypted files are stored. At the same time, we know what everyone's looking for. We know all the keywords that what kind of technology people are searching for. So we run all those keywords against all the encrypted files, and if there's a hit, the person searching is told there's a hit. They're not told what it is. Ideation doesn't know what it is, it's encrypted. They're not told who it is that owns it, but they are able to send a message to the owner of that proprietary technology and request access. And to make it more likely to be granted, they can attach a 2-click smart contract NDA with that request. So now you can market secret IP without having to disclose it to anyone. You don't disclose it until you have an NDA in place and you're safe and secure, you know who the other party is, and you feel comfortable. And we're testing that with Ukraine because Ukraine's got hundreds of thousands of brilliant PhD scientists all getting by on $500 a month. They can't afford to get a patent. So we suggested send it in as an encrypted file, and there have been a few transactions based on that. So that's basically, I think, all I wanted to say. Now I'll pass it over to our very capable panel, and perhaps we'll start with some, actually what I'll do initially is I'll ask the panel to each reintroduce themselves, even though they've been reintroduced once, say a little bit about their particular interest in privacy, what they're working on, And then perhaps we'll start with some questions. I've got a few questions. I've got a lot of questions. And hopefully you've all got some questions too. You always get priority. So I'll just ask the panel to go down, introduce themselves, maybe say, take a few minutes to talk about their particular interest in privacy, and then feel free to ask questions as they go through it. We'll keep it very informal. And I think we have plenty of time, so we should be able to get through everything. Thank you.
Again, thanks for coming on in a very busy 2 days. And my name is Elizabeth Chien-Hale. I'm based in San Jose, California. My firm is Appleton Roth. We are an international trade firm. As intellectual property gets more and more folded into trade issues, I and my partner has a San Jose office. We specializes in IP, prosecution, transaction, and that's us. So I think this slide dovetails into what Doug was just saying. Those of you who have seen me at this conference, I've been speaking here almost every single year since the beginning. And I usually speak on strictly IP issues with respect to the US, with respect to China. And this year, people might ask, why am I talking about privacy and data protection? This is a brand new area, and a lot of times IP professionals are drawn into this, especially somebody like me, because I do a good portion of my practice is helping US companies to navigate the legal landscape in China. And privacy laws are on the rise in China, which raise a lot of concerns, and therefore I'm diving into privacy laws. But then allow me to make you large. I'm happy to share with you if you approach me afterwards. So the basis of privacy goes from constitutional, our states have constitutional, to constitutional law to health law to a variety of things. And now this says, I know we have an international audience. I don't think you'll be interested in deep diving into compliance issues based on the state laws. So I'll give you some interesting examples between US and China. So in addition to the tariff fights that you heard about, US and China have really been fighting with regard to data. I'll give you some interesting examples. For example, US, especially toward the last days of Trump administration, they made a sincere effort based on I will call ambiguous basis law that they want to get rid of these Chinese apps. I don't know if anybody here, I have a feeling these apps are also banned in India. They're banned in India as well. So, and why are they banned in India? Probably for the same reasons the US is banning, right? Where is the data stored? Is the Chinese government going to have access to these data? But anyway, fortunately, since WeChat is used by so many people in India, and TikTok is just growing. And so fortunately, they didn't get taken off on app stores. China is equally doing its own thing with the US. So there are famous examples of the listing of Chinese companies that are listed in US stock exchanges. As you know, China has its own stock exchanges, but they're far smaller and capital is not nearly as the US stock exchanges. We are, the United States, still by far the largest place where companies can raise money. So, but in exchange for that access to US capital, US SEC, the regulators, demand you to do certain disclosure requirements, which raise the hackles of the Chinese government. So, for example, if Didi is an app, I think in India it's called Ola, right? That's your Uber in the US. This is kind of analogous to those apps. So Didi listed in the United States. Well, that raised a big concern because the Chinese said, oh my gosh, you're going to have to report, you might have to report every Chinese citizen moving everywhere in China to the US government. That is not going to go. But Didi didn't listen. Didi jumped ahead. Didi listed at $15. Now they were punished pretty severely. They got, I think, $1 billion fines. In addition, they were forced to list. The big losers, actually, are the investors in the United States. The stock prices went from 15, and if they listed, of course, there's no value, but it's still traded on the stock exchange. The last time I looked, it's at $4, but a pretty big loss for the kind of innocent investors. So we could all be kind of casualties of these cross-border data fights. Well, China also has its own data privacy laws. I'm not going to go into this. I have an article that's forthcoming about each one of them, the 2017 cybersecurity laws, 2021 data security law, and the latest is the personal information protection law. That raised a lot of concerns for US companies. Why? Because European companies are now concerned that now, whether they're going to build a firewall, they need to kind of have storage in China, and let's think about pharmaceuticals. A lot of pharmaceutical professionals here. What are you going to do with, say, your clinical trial data? Can you transfer them cross-border? What kind of reporting do you have to do? So it raised a lot of concerns. Chinese government recognized that. They're trying to step it back. But ironically, the biggest victim is the company I just mentioned. It's a Chinese company. There's another high-tech darling in China, Tencent, which operates that WeChat app, which is used by everyone. It goes from payment to messaging. It's like something that Elon Musk wants to build in the United States. So Tencent recently lost $43 billion in market share because the Chinese government decided they only proposed regulation to regulate online gaming. So again, these privacy laws not only protect the consumer, but has real financial consequences for the rest of us. Okay, thank you.
Okay, thank you. Curious of the different privacy laws in the different geographies, and maybe that's one time there's a useful role for some kind of global governance, because if we are going to have a role, it may make sense to have one privacy law, but I'm not sure that will ever happen, but it would be nice. So maybe, Shabana, would you like to introduce yourself and just talk about the kind of cases you're working on and your perspective on privacy law and the UK perspective as well on privacy law.
Thank you, John. First of all, thank you for the audience as well for making it this early in the morning. So I'm Shabana. I am a barrister from London, UK, and I'm also the Vice Chair of the Legal Services Committee for the Bar Council of England and Wales. And I head the AI initiative and think tank on artificial intelligence, especially in the legal services, but also in society generally. We know I'm proposing not just to talk about data protection, but principally about AI and the way that is being involved in strategy with data protection. We know that AI is rapidly advancing technology with immense potential to revolutionize industries, contribute to economic growth, and transform various aspects of society. And the UK government has identified AI as just one of the 5 critical technologies in the UK Science and Technology Framework. Currently, 1/3 of AI companies in the European Union are based in the UK, and the UK has also emerged as a dominant force in AI, positioning itself as a global leader in research, innovation, and talent. So the government is poised to maintain this leadership for the next decade, benefiting from a progressively regulatory and business environment. So in terms of what I was proposing to do is, first of all, to give some kind of information that's useful to the participants. As one is just to take you through what UK is actually doing with regard to that, and also to try and give you some proper key guidances that you might be able to use and implement with the way India is seeing. Especially we have a lot of unicorns, a lot of technology, and we're in technology hub, Silicon Valley of India here in Bangalore. So we know very well how do we implement proper AI in an ethical and effective legal format. So that's what I'm proposing to do here for that. So let me just give you, instead of boring you with too much with GDPR, in terms of data protection, UK has this general data protection regulation incorporated into the Data Protection Act of 2018. I'm not going to go through all those formats in there. If you need to have any discussion on that, I'm happy to do that. But more than that, I thought I'd deal with much more of a kind of information as a roadmap as to how the UK is dealing with regulatory and what their proposition is. And then go on towards giving you some kind of key guidances that will go through it. So we know that in around January 2022, the government announced an initiative that was led by the Alan Turing Institute. The Alan Turing Institute is the national kind of data regulatory and research hub based in London, and it's got places around the UK. And essentially it provided an idea of the UK's AI standards hub, which was officially launched in October 2022. Now, the UK's, the hub's mission was to advance trustworthy and responsible AI, focusing on use of standards as governance tools and innovation mechanisms. It operates under 4 pillars. First of all, it's the observatory, a kind of a web tracking global AI standardization on related developments. It includes AI standard databases with catalogue standards being developed or published by relevant standard development organisations. The second pillar is the community and collaboration. That's to facilitate collaboration, exchange ideas and problem solving among stakeholders. The third is knowledge and training, providing resources for effective engagement with AI standardization. It offers e-learning materials as well as in-person trainings for stakeholders. And finally, of course, it's the research and analysis, conducting strategic research and inform standard developments, etc. Now, we know very well that the UK has taken a very pro-innovative stance for development in AI, and the UK's initiative is to shape kind of global standards in artificial intelligence. So with regard to the recent publication of the UK white paper, that was the government's approach mainly is to aim at striking a balance between fostering innovation and instilling public trust and ensuring ethical and responsible development in AI. Therefore, the government has gone ahead with this kind of pro-innovation approach, which focuses on regulating the use of AI and not on the technology itself. And the aim is to avoid creating kind of cumbersome or overbearing regulatory environment that will stifle innovation. AI can be applied in a plethora of different contexts, from generating summaries to producing medical diagnosis. And all sorts of information that's coming out. So while the use of AI can be beneficial in both contexts, the later, for example, medical diagnosis carries a much more higher risk than former. So it highlights the unsuitability of a one-size-fits-all approach to regulation, and that's why they've decided to have this kind of much more broader regulatory kind of remit done by different regulators. So the 3 key objectives is to drive growth and prosperity, increase public trust in AI, and strengthen the UK's position as a global leader. And I think the only way they're going to do that is actually having proper collaboration with other countries around the world globally. And I think that this is why we have that strengthened relationship to grow and foster and grow properly in different areas. Personally, for me in my practice, I find that there is a lot of AI ethics that has to be embedded so that so we can deal with things like discrimination and bias, etc., and everything else. I'll just give you a few key guidances that have come through. One is the first one is to do with the government's the ICO's the data ethics framework, which was embedded back in the earliest one with regard to how AI can actually be done. Now, this was really principally done for public sector, but it's a good framework that you can actually download and use in order to deal with. Although it's public sector, it's mainly for the public sector, because the way that the different police forces are using AI in tracking criminals or trying to identify information. actually it can also be used because there's a lot of public and private collaboration as well. So I would say that's a good framework to actually look at and think about those main kind of areas. And as you can see, transparency, accountability and fairness are three of the main principles that are really to be taken into consideration. Following on from this, we also have the ICO. The ICO is the Information Commissioner's Office, which is the main regulator for data protection. As we say, we don't have one regulator for AI, but we have different regulators dealing with different domain aspects of it in order to actually cater more prominently for those different areas. And here we have the explaining of decisions in AI. As we know, one of the major grey areas with regard to artificial intelligence and the use of artificial intelligence is to actually clear up the black box syndrome. How do we go with explainability? So you'll probably find this guidance quite useful, which is actually split into three parts. The first part is mainly on the basics of explaining AI, aimed at really data protection officers and compliance teams, but it's also relevant to those that are involved in the development of AI systems. The second part is more about explaining AI in practice, aimed at technical but also helpful for data protection officers and compliance teams, but part of the guidance considers the design and development of explanations. And the beauty of this is it's done in collaboration with a field of professionals, so not just lawyers, but a collaboration of technicians as well. We have part 3, which explains what AI means for your organisation. It's aimed at senior management and it's part of the guidance looking at individuals likely to be responsible for drafting any kind of explanation and role in that process. So they're kind of useful guidances. The other ones that are important, obviously, is the guidance on AI and data protection, which is published again by the ICO, and that was done and updated from March 2023, and it's split into 7 parts really about what are the accountability and governance implications of AI, how do we ensure transparency in AI and ensure lawfulness, fairness, and also to address security and data minimization in AI, and to ensure that individual rights are forward. So I think you'll get these slides afterwards, but you'll find those QR codes should give you the information to the actual guidances, and I'm just hoping that you'll get some practical input. There is a wonderful video on AI and data protection risk tools analysis, which you will find really helpful, hopefully, for when you're trying to implement it with a lot of your startups and tech in enablers, and how to use AI and personal data appropriately and lawfully. Because if you look at it from this framework, and I would say that this will really help your clients in getting the proper investment deals when they need to. Because one of the things that you look at when you're looking at new technology and IP, etc., it's about how is that being implemented abroad, and how is it actually being catered for. So I don't just deal with disputes in resolving disputes, but I also try and help with mitigating those disputes. I'm usually called on to boards, etc., to try and find out ways in which we can implement those sort of strategies in order to try and mitigate them as much as possible. So these are a few of those kind of practical guidances that you get. I'm not going to go through all this at the moment, but you'll find that a lot of the strategies that are required for how to use AI and personal data appropriately and lawfully is available from those information. But I think I'm running out of time, so I'll pass it on.
Thank you for the interesting perspective, particularly on the AI aspects, which I'm sure we're going to be talking about quite a bit more. So Beatrice, if you could give us we just had a great perspective from the UK, if you could give us a little perspective from the Spanish point of view.
European.
And particularly, of course, in Spain, you're going to be under the AI Act as that comes out. So we're all curious about what's the problem that's going to be solving. How are they going to solve it?
Thank you so much for being here. My name is Beatriz. I'm Spanish. I'm a qualified lawyer, but since 10 years ago, I'm fully dedicated on privacy. And I've been working for NEC, which is a Japanese company, for almost 5 years. So I will give you my personal opinion, but from a corporate side, as an in-house lawyer, leading with this kind of projects. So first of all, I would like to start saying, or giving you my approach of what happened at the end of last year. Because we start hearing the news, even in the European news, wow, Europe has already passed the AI Act, So the first law regulated AI in the world. And well, when you start digging, that was not really accurate, right? What Europe already agreed is what it's called the trilogue agreement or political agreement, which means that basically the Parliament, the European Commission, and the Council agreed on those items where they were debated, and they were not agreeing in any particular solution. So this is what happened last year. Does it not mean that we have an AI Act? And next steps will be that from January, after Christmas break, they are conducting technical negotiations. Different stakeholders are involved. That will be happen during January, maybe February. They will translate the basic terms of that agreement into a proposal text. Then the Parliament needs to be approved, that proposal text. And if everything goes well, that we will see, I have my doubts, in June 2024, we will see the AI Act published in the European journal, official journal, So there's nothing else yet. Let's have that in front. And I think that is important. What they have already agreed. It's first in the definition. There were discussions about the definition of AI. It was already agreed, and basically they are taking the OECD definition, but they are incorporating the term content, because there was a lot of debate to the old and previous definition, because they were considering that the generative AI was not covered under the AI Act. So finally, we have a definition. However, I have my concerns because that definition is so broad. So we will need to see what happens in the final text. The obligations and the 6 principles remain the same, so I'm not going to go through it. High risk, they keep the classification of AI systems, and they are also including high-risk sectors on that agreement. And I would like to highlight, because they are education, employment, critical infrastructure, public services, law enforcement, border control, and administration of justice. However, there are several exceptions. They also include or confirm another obligation, which is when we are talking about high-risk AI systems in those sectors, there is another and additional obligation that deployers need to conduct what is called fundamental rights impact assessment. So additionally to the conformity assessments, blah, 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 and the huge burden requirements, there is another one, So companies will need to ensure that the system, the AI system, safeguards individual rights, human rights, and it's aligned with ethical approaches. And also, another thing that they have already highlighted is that individuals can lodge complaints. But this is an open question to you. How? How are we going as individuals requesting companies that are dealing with AI to provide me with how can I exercise my right of access related similar to the GDPR? I think that's very, very challenging. Basically because we don't know where is the data that those companies are collecting from individuals. Another thing that I would like to highlight with regard to this agreement is that, there are many systems which are banned, but they have amended those provisions, and they are also including AI systems related to emotion recognition, mostly in the employment context. Also real-time remote biometric identification and ex-post remote biometric identification. They are also in the list. And something that is important, I think, for this audience is that they are also including the obligation to have a copyright policy. And this copyright policy needs to be aligned with the European copyright laws, which basically they are right now reviewing because they want to update the copyright framework in Europe in 2024. They also state that this copyright law needs to be aligned with the Digital Service Act, the Data Act, and the 5 acts that are going to be published in the future related to the strategy in Europe. So I think that there are many challenges around the AI Act, and we will need to see and digest what the European Commission is going to deal with these kind of matters, because there are also several exceptions, and they are allowing member states, to take actions in many provisions. And this is always a nightmare, if you are allowing member states to make their own considerations related to several provisions, and we suffer when the GDPR came into force. This is basically the scope in Europe. As a UK, we are dealing this kind of strategy, but right now UK and Europe are enemies, right? So who is more important, Europe or UK? Which basically I think that you can see that it's more or less the same approach, but being focused on privacy, and dealing with AI systems. I want to highlight what I think are the most challenges when we are talking about AI. And very briefly, because we have 2 great panelists waiting to talk, but basically data protection laws around the world have the same aim, right? Protect individual rights. So individuals need to have the control over their personal data during the whole life cycle. With that, and taking into consideration what an AI system is, that's very difficult, and it's going to be a conflict. Let's think on the data collection, for instance. AI systems rely on massive data sets. Some of them can contain personal data, others don't, So basically, there is a conflict with the basic principle on many data protection laws around the world, which is the limit the collection of data. It's impossible, right? How can we ensure that that data is accurate, and it's intuitive? Having in mind that AI systems can collect data directly from individuals, but also indirectly if I have a chat, with ChatGPT, for instance, So the system will be also training with indirectly that. The purpose, well, yeah, there is an original purpose, but AI systems can extract the data and use for different meanings and secondary purpose. And it's going to be very difficult to control. And also the use. I don't think that we are all prepared to inform individuals and in order to comply with the transparency principle. We don't know what is behind all these AI systems. Data sharing, that is another issue, right? With whom my personal data will be shared? We don't know. We don't know, and we will need to
It'll
start.
probably come up in question.
Storage, yeah? For how long? Yeah? But basically, I see many privacy challenges that companies need to start thinking on. So that's why I think it's important in the next couple of years, and this is the trend that many companies are following up. Privacy professionals were dealing with data protection governance framework, and we get used to it. We know which are the policies, the procedures, yeah, the rules to deal and to protect individual rights. So there is a trend, yeah, over the world to start using these data protection frameworks and adjust it a little bit to the AI governance framework. Of course, and that needs to be adjusted because, of course, there are many other things that we need to consider when we are talking about AI. So that goes beyond privacy. So yes, this is my personal recommendation.
So
Thank you.
Thank you very much, Beatrice, for shining light on the